Good afternoon. Thank you so much for joining us for the Maricopa County Attorney's press conference. I am Mayor Julia Wheatley for the town of Queen Creek, and I would like to acknowledge who is with us today. We have Maricopa County Attorney Rachel Mitchell. We also have State Legislator Matt Gress and our Queen Creek Chief of Police Randy Bryce. Before we begin today, I would like to take a moment to recognize the significance of today's date. 23 years ago, we were desperately trying to comprehend the tragic events that took place on September 11th. We remember the lives lost, the sacrifices of so many, especially our first responders, and the continued impact to our country. And it is in that spirit that we gather here today to take opportunities to enhance safety. And I am so appreciative of our County Attorney Rachel Mitchell for asking us to host this press conference in Queen Creek today, and am so appreciative of the great working relationship that we have with her office. As we approach the 1-year anniversary of the awful events that took place on October 28th, it is so important to remember Preston. And it is important that we continue to work together to enhance safety in our community. We are here to support the County Attorney Rachel Mitchell, her proposed legislation regarding teen violence and aggravated assault. And I would now like to introduce our County Attorney Rachel Mitchell, who will be providing details about the proposed legislation. Thank you again for joining us today.
Well, thank you everybody for coming. Hopefully this doesn't cover up any microphones. Thank you, Mayor Wheatley, for having me here to inform you and the public about the steps we are taking to curb teen violence. And as you have seen in past press conferences, this is just one step. This is a tragic reminder of what happened almost a year ago to Preston Lord and to his family. But it is rewarding to have people coming together to address the situation, to have Queen Creek Police Department, City Council, the mayor, as well as others coming forward from the legislature so that we can deal with this situation and not have it happen again. For the past few months, my office has been researching the situation and crafting proposed legislation to take action in holding teen violence offenders accountable. When the cases of the East Valley teens started making their way to my office in late December, early January, one of the biggest challenges that we faced was the limitations of the current law. The way it stands right now, unless an offender causes serious physical injury or uses or fashions a weapon or causes substantial injury, such as a broken bone, these crimes under the law are considered misdemeanors. When we charged some of the cases, we were able to raise the misdemeanors to Class 6 felonies by alleging that the victim's ability to resist was impaired. Now, this provision of the law is normally reserved for victims who are actually restrained in some way, but it still fit our set of circumstances because of the number of attackers involved that were either attacking or surrounding the individuals. But as most of you know, Class 6 felonies are able to be made into misdemeanors even after trial. When I teach others about them, I describe Class 6 felonies as being sort of a purgatory, if you will, between misdemeanors and felonies. And that simply does not speak to the seriousness of these crimes, especially to our young people. So the legislation that we are proposing will change that. We've called the crime that our proposal addresses swarming because, much like it sounds, this is focused on people who team up and beat up on a single individual. This is for the most part what we have been seeing in recent cases of teen violence, 3, 4, 5 or more people targeting one person. This mob mentality that is demonstrated in these cases is significantly more dangerous for the victim, and that danger needs to be reflected in our laws. The proposed legislation adds language to the current law that if you commit an assault and are aided by 2 or more accomplices, the charge would be a Class 4 felony. A Class 4 felony will allow for stronger punishment than a Class 6 felony or a misdemeanor to those who decide to take part in a gang or group beating. A Class 4 felony is also a permanent felony that cannot be turned into a misdemeanor. This swarming legislation will, of course, need the support of lawmakers. And for that, I have invited Representative Matt Gress, who represents Legislative District 4. We also have another co-sponsor who was unable to make it today, Representative Julie Willoughby from Legislative District 13. Both of them have shown a commitment to the rule of law and to prioritizing victims and the safety of residents, particularly young people. So I will turn it over to Representative Matt Gress to give you a few words on this effort. Matt.
Thank you, County Attorney Mitchell. My name is Matt Gress. I'm a state representative in the Arizona House, representing District 4, which includes Scottsdale, Arcadia, Paradise Valley, and North Phoenix. But I'm here today in the town of Queen Creek to stand in strong support of County Attorney Mitchell's efforts to advance in our next legislative session a bill that would increase penalties on swarming. You know, the town of Queen Creek knows painfully well the dangers of swarming. Preston Lord, the loss of Preston Lord at the hands of a brutal teenage mob. It's unacceptable and it deserves a statewide response. Just imagine being attacked by 3 or 4 or 5 people. It is scary, it is frightening, and we know that it increases significantly the risk of serious injury or even in Preston Lord's case, death. So if I could leave you with one thing, it is this. We hear you, and next January, the Arizona legislature will take action on County Attorney Mitchell's legislation. I want to thank County Attorney Mitchell for her leadership on this particular issue and for keeping the residents of Maricopa County safe from criminal activity. Thank you. And now I'm going to introduce the Chief of Police, Chief Bryce.
I'll keep my comments brief, but I wanted to provide a couple of thoughts and comments. But first and foremost, I too want to thank the Maricopa County Attorney Rachel Mitchell for her leadership in this and really coming to the table with solutions on all these different problems that we're dealing with. And for Matt Gress and Julie Willoughby, who's not here, for their courage to stand and sponsor this bill. As Mayor Wheatley so eloquently talked about, this day is particularly important for first responders and for those that, as we remember back to 9/11, we saw hatred and intolerance that was kind of the core of that event. But we also see something beautiful out of that, courage, conviction, love that came from those that helped others and to buoy up those people that were having, or that were affected most. As we talked about this already, but as we approach the anniversary of Preston Lord, I did have a chance to communicate briefly with family today. And as we talk about these things, it's difficult because it's still tough for the town of Queen Creek and for the Queen Creek Police Department, and especially me as I continue to deal with these issues. This is a very difficult thing for our community. And this type of legislation shows and demonstrates what happens when we come together as a community, as a state, as different organizations, that we can be stronger together. If we work together, we can solve big problems with just these small things. Now, this effort's going to provide new tools, better tools for law enforcement, but most importantly, it's going to hold violent offenders accountable, especially in these cases of swarming. So I really do want to thank the county attorney and her leadership, and again, the legislators that are sponsoring this bill, and for you today coming here and talking about this important event. I appreciate this, and I know the family appreciates it, and we will continue as a law enforcement agency, especially for the town of Queen Creek, to find ways to make these changes and to improve the way that we approach these problems and to make our community safe. Again, it's all about coming together. That's what we talked about from the very beginning. I thank you for your time, and I'll turn the time back over to County Attorney.
Thank you, Representative Gress and Chief Price. And with that, I'll open it up for any questions that you may have.
Rachel,
Morgan.
to follow up on this piece of legislation, this gives prosecutors a new tool, but it seems that one of the problems in this sort of string of cases is that your office wasn't made aware of these. These cases had not reached you. Do you think that a year later that the police agencies, the police officers who are on the ground, the SROs, are becoming more aware of maybe some of these trends so that they take action sooner?
You know, I think that, as we've discussed in past press conferences, that, you know, what it's looking like now is different than we have seen in the past. And I think now that people understand what this type of activity looks like, certainly people are on the lookout for it. They want the tools so that they can enforce the law and hold people accountable. So, yes, absolutely.
And ask another couple of questions here from our newsroom. This one has to deal with Saul Ball, who was arrested last week.
Yeah.
There were several instances where he fell through the cracks, not just in Maricopa County, Navajo County, Albuquerque we saw, but in the situation where he was arrested last year, last May. Do you have an understanding of what happened and why he wasn't prosecuted?
You know, I went to the hospital the night that those officers were shot, and I was sitting there looking at his criminal history that night. And, you know, this is somebody who, as you pointed out, 90+% of his criminal activities were in different states, California, New Mexico, as well as different counties. And, you know, what we saw there was a long history, but not a history of anything that would look like what happened last week. That doesn't mean that he wasn't held accountable. As you know, he was actually on parole from a prison sentence when this happened. In fact, I believe he was 2 days out from having ended his parole time. So it's a series of events that he committed that where he was held accountable in many of those, but the timing was very bad. And obviously the situation was beyond tragic.
And specifically, when he was arrested in May, your prosecutors asked for additional tests to be done on some drugs. Police department has admitted they did not contact your prosecutors. Should there be some kind of system in place where your office is automatically notified that maybe an extra evidentiary test is done?
What we have done is we've looked at our way of notifying the police departments that there is still what we call a further for more investigation outstanding, so that we're going to be doing that. But the bottom line is, would that have made a difference? Probably not. The reality is, when he was arrested for that back in May of 2023, he received an OR release, meaning he was let out on no bond. So he was already out before that case was even furthered by our office or even received by our office.
One other question here. This is about child abuse cases. Octavia Rogers is not getting the death penalty. She insanity defense. There are two other cases that have similar situations with parents and deaths of children, Rachel Henry and Carlos Cruz. What goes into the process of accepting an insanity sort of plea or defense in this case? And in all of these cases, DCS had encounters, multiple encounters, and should they be doing their job better so that it doesn't come to this?
You know, a lot goes into it. Anytime that somebody is looking to plead insanity as a defense, I can tell you that we have our experts look at it very thoroughly, as well as there are court experts, there are defense experts, and the reality is we vet it very carefully to make sure that that is actually the case. In a situation where DCS is involved, I would have to look specifically at the records in this particular case to see what they were aware of at the time. As somebody who prosecuted child abuse cases, I can tell you that sometimes, you know, you don't know what's going on behind the four walls of a house, whether DCS was aware of anything that would put it at that level of concern. I'd have to look at the records.
County Attorney Mitchell, there's 3 sex crimes cases our newsroom has been following pretty closely. The first is Cody Weaver, that's a possession of child pornography case right here in Queen Creek. There's Joe Kinney, the Buckeye principal, sexual exploitation of a minor, allegations, and then Carl Komorowski, who was just involved in an officer-involved shooting, had a case further back to law enforcement that was sexual exploitation of a child. What does your office consider when you decide to further a case back to law enforcement, turn it down outright? What are some of the things at play there?
Well, obviously, the charges in the one case, Kenny case, are different than the other charges. What we're looking at is whether the elements of the offense, meaning the different things that we have to prove in court, can be proven beyond a reasonable doubt, or if there is a possible defense, not necessarily a true defense, but a possible defense out there that we can make sure that we're able to disprove beyond a reasonable doubt. In the Kenny case, for example, we have to show that the person, Mr. Kinney, knew or should have known the age of the person he was talking to, or the age being portrayed by the undercover officer. We also have to show that he had an intent to follow through and actually commit acts. Those things were lacking in this case, and therefore they could not be proven beyond a reasonable doubt. As to the other cases, what we're doing is shoring up the strength of the evidence before we go to court. And, you know, sometimes that can be done as you're going along after you have filed charges, but in those 2 cases, we felt like we needed to get that solidified, because oftentimes it involves examination of, you know, phones or digital evidence, that we have to make sure it's there and we know what it is before we go ahead and file charges on those.
In 2 cases that were further, the Komorowski and the Weaver case, these are situations where these potential defendants were arrested, held, they were booked, they had a mugshot taken. We just interviewed Carl Komorowski's wife, who said she noticed a difference in his behavior after he was arrested. Do you believe that there is some sort of change in behavior after they know law enforcement's onto them and they've been booked?
Well, I mean, certainly that's something that is going to, you know, tip them off to information that is ongoing. Yes, absolutely. But I would also point something out in terms of these cases. Obviously, that is my background, and I take these cases very seriously. You know, the units that are dedicated to prosecuting sex crimes cases in our office, I just looked at the numbers before I came. In August alone, just related to child sexual abuse, not related to adult sexual assault or anything, we filed 37 cases in August. Right now, pending trial in those 2 units of all sex crimes cases, there are 618 cases pending trial. So this is a very aggressive, very dedicated unit, or 2 units of people that go after this. So when they say we need additional evidence, that should be taken seriously. They know what is required in court, and they are trying to shore up the case so that we can best protect the community.
I just wanted to ask one softball question, if I could. Just got some records from his previous Navajo County case. This was possession of contraband in a facility. He was convicted, accepted a plea agreement, and was sentenced to a half year in prison in the Department of Corrections. This was his most recent case. Prosecutors in that case chose to not add enhancers because he was a multi-time convicted felon. That's written in the documents. Is that something you think they should have done because he was a multi-time convicted felon? Could they have?
You know, without reading that case, it's hard for me to second guess a prosecutor who has read the case. So I think Navajo County would be in a better position to answer that question. Bianca.
Yes. Okay, so first, a quick question about the legislation. I know it's very early on in the process, but so far, have you guys received bipartisan support?
We have been reaching out to various legislators, and at this point, we're trying to get the language down. We're trying to get sponsors in place, but I have no reason to think that we will not get bipartisan support in this situation. This is definitely something that is going on that needs to be addressed, and I'm very hopeful that from the legislature on up to the governor, they recognize the need for this legislation.
And for those who don't work in the court system or aren't familiar, can you just talk briefly about the difference between a Class 6 felony and a Class 4 in terms of the punishment?
Sure. In the Arizona's criminal justice system, we rank felonies from Class 1 to Class 6, 6 being the least serious. But the Class 6 felony is able to be designated or made into a misdemeanor even after trial. And in fact, while it is pending, it is treated as a misdemeanor for many purposes, most purposes. And so when I describe it as, when I'm teaching, as sort of the purgatory between felonies and misdemeanors, that's why I use that term. So we could go to trial on the cases that these individuals have been charged with and still end up with a misdemeanor. This way, when you have a 5 or higher level felony, those are permanent felonies. They can't be turned into misdemeanors. And so that's one of the considerations. But the other consideration is, as you go up on the continuum, harsher penalties apply. And we recognize from this type of behavior that whenever you have a group of people acting with group mentality, you have a greater danger. And the law needs to reflect that with the sentencing.
And then I just had a couple follow-up questions on the Joseph Kinney case, the principal out of Buckeye. In reading through the Form 4, the piece of the conversation that was publicly available to us, the undercover agent mentions that they are posing as a 12-year-old girl 2, maybe even 3 times in that conversation. Why is that not enough to reasonably believe that Kinney would have thought he was communicating with a 12-year-old girl?
Without going into other things that were done as part of that investigation, what I would say is there were other factors that were present there that might cause him to question whether that was in fact true, that the person was actually talking to somebody that was that age. As I mentioned in our statement that we released, there was an age-regressed photo that certainly could have been taken to be an older person and caused them to question whether that was actually true.
And then his defense, again, according to the court documents, was that he thought this was role play or fantasy. What is to stop anyone that is a child predator from using that as a defense?
Well, that's not an uncommon defense used, that this is role play or fantasy, disturbing though that may be. But that's why the investigation has to contain certain elements within it to make sure that we can rebut that. That's what I was talking about earlier was we don't just look at the elements that we have to prove, but we look at what the likely defense is and can we disprove that likely defense. And that's why that investigation has to include those certain safeguards to make sure that we can. Those didn't happen in this particular case, unfortunately.
And last question, why did your office choose to turn down the case as opposed to further it back to police?
Because the elements that needed to take place were not available to us after the suspect became aware of the investigation.
Rachel, back to Saul Ball real quickly. Are you going to change the bail asks for prohibited possessors, and do you think the courts will follow?
We actually have been changing bail asks for the time I've been in office. We have been really paying a lot of attention to that. I think that bail amounts had gone down significantly before I took office. And, we've seen across the country where, for example, no bail has been tried, and it has failed. Every place has been tried. So we have been trying to drive the bail amounts up to an appropriate amount. Misconduct with weapons is something that we have been paying particular attention to because we have seen an extraordinary correlation between people who commit misconduct involving weapons. And let me explain what I mean by that. Misconduct involving weapons is a felon who is in possession of a gun where his or her rights have not been restored, and then later violent activity. I actually mandated training by an expert for every attorney in our office, and she specifically addressed that particular crime. and said, whenever you have a felon in possession of a firearm, you automatically have 3 risk factors. You have somebody with a criminal history, you have somebody with a firearm, and you have somebody who's willing to ignore the law. And so I take those cases very seriously.
Time for 2 more questions.
Yes, ma'am.
Elena with Arizona Republic. So
Hi.
back to this legislation, we keep hearing over the months since these kids in the group attacks have been, they've been taking plea deals. We've heard a lot that, and those are reduced. Many of them have been probational, but or most of them have been probation. With this legislation, you saying wanting harsher penalties, could you explain why these plea deals have gone down to just probation and not much of jail time?
I think what people don't realize about Arizona's law is that unless there is, for example, a weapon or a prior felony conviction, not as a juvenile, but as a prior felony conviction, the vast majority of offenses are probation eligible, which means they could take it through the entire process, we could go to trial, and they could get probation or a misdemeanor in this situation. So we were taking that into account. But I would remind you that while there were plea deals entered, the plea deals had many of them pleading to the Class 6 that they were charged with, number one. Number two, there were situations where we did ask for additional jail from the judge who likely would have been the sentencing judge after trial, and in some cases we got it, and in some cases we did not. So that's one of the reasons that we made the plea offers we did, because we know what the outcome after trial is likely to be.
Last question.
If this legislation gets through, say there is a group attack in a year when the law is green lighted, and you have a first time offender, it's still a higher felony. Is there a chance that you could still get probation?
It's still a probation eligible offense. However, the difference is they will not be able to say, well, I could go to trial and get a misdemeanor. And so we can, keep that as a permanent felony on their record. Plus, the sentencing range that they're facing is higher because it's a Class 4. Yeah. All right.
Thanks, everybody. I think Chief Rice and Mayor Wheatley and Mr. Grass are all available if you'd like to talk to them.
Thanks, everybody.